is actually just hand over to our wonderful partners and Employment Hero, Courtney and Simon. Courtney's going to kick us off with some introductions, and then we're just going to dive into it with all the expertise from Simon and Courtney. You guys can take it away.
Excellent. Thank you so much for the warm introduction, Heather. I really appreciate it. As the headline suggests today, guys, we will be discussing the 3 employment law changes every care provider should know. Now, this is our first webinar in partnership with Shift Care, and we're very excited to be here. So, Simon, I'll get the next slide up, please. There you go. Now, we have a stellar cast on today's webinar. As already mentioned, we are joined by Simon Obee. So Simon is the head of HR advisory at Employment Hero, as well as the principal lawyer at EI Legal. Simon is extremely well versed in employment law with decades of experience in firms across the UK as well as Australia and in House of Government. He's a thought leader in the employment law space, and we are very grateful to have him on the call today. Now, when Simon isn't navigating complex workplace matters, he's a dad to 3 beautiful boys and a DJ on the side. We are also joined today by Annie Palazon, HR Advisory Manager at Employment Hero. With a bachelor's degree in psychology and postgraduate qualifications in human resource management, to say Annie is a people person would be an understatement. When she's not our guiding light in HR advisory, you'll find her hosting an Eras Tour worthy Taylor Swift performance to a fur audience, 2 perfect cats, and a pop name whiskey. She will kill me for that. Then there's me, Courtney, the Partnership Manager here at Employment Hero, or as I like to call myself, the Chief Delegation Officer. So in true delegation fashion, I'm going to take us through the agenda. So next slide, please, Simon, and then I'm going to hand over to him for the rest. So we do have a fair bit to get through today, and top of the list are those upcoming changes to employment law and essentially how they impact care businesses in Australia. So Simon will be walking us through the right to disconnect, changes to engaging casual employees, and changes to engaging independent contractors. We're also then going to look ahead to potential award changes with the SCHADS Award, aged care and nurses, as well as portable long service leave in New South Wales. Then Annie and I will both jump on at the end and discuss how to prepare internally and what your next steps could and should look like as a business in Australia. So without further ado, I'm going to delegate the next responsibility over to Simon to take the reins from here.
Thanks, Courtney, and good afternoon to everyone, or good morning if you're still before midday, wherever you are. So look, I'm going to talk for about half an hour, I think, and then we'll have plenty of time at the end for questions and to look at some features of Employment Hero. So there's quite a lot to get through, and some of this stuff are only really going to be scratching the surface, but at the very least, it should give you some signposts of things to look out for. So kicking off with the right to disconnect, this is one of the, I guess, the three big things which are changing on the 26th of August. So for employers with 15 or more employees, 26th of August this year is when it all happens with the right to disconnect. But for smaller businesses, less than 15 employees, you've got until the 26th of August 2025 to prepare for this. So in a nutshell, the right to disconnect gives an employees a right to refuse to accept contact and a right to refuse to monitor for contact outside of working hours. And that contact could be from their employer or anyone associated with their employment, so colleagues, clients, participants, etc. But it is not an unlimited right to disconnect. They can only refuse contact or to refuse to monitor contact when that refusal would be reasonable. So that is obviously a lot to take in. So I'll kind of rewind back and break it down a bit more. So the right to refuse to accept contact, that covers things like ignoring a phone call, not replying to an email or a text message. It's that sort of thing. But there's also this right to refuse to monitor for contact. So that is things like, you know, I'm not going to check my phone, or my phone will be off, or I've left my laptop at work. I'm not going to monitor for any contact that is trying to be made to me. So I hope that makes sense. The other thing, which I think is something which got a bit of lost in translation with some of the commentary about the new right to disconnect, it is just concerned with the period of time after an employee's working day has finished. So whether they've worked a long day or a short day, whether they've done loads of overtime, it's not to do with working hours. It's whenever their shift has finished and the working day is over, that is when the right to disconnect bites. There's already separate protections for working excessive hours, etc. But we are just talking about when the working day is finished. That is when the right to disconnect is engaged. Now, the other kind of really key point is that it's not an absolute right. It is only a right to refuse contact where that refusal is reasonable. Now, of course, the million-dollar question is, well, what is reasonable and what is unreasonable when we come to refusing contact? And helpfully, the Fair Work Act lists 5 factors which are relevant to determining that question about whether out-of-hours contact is reasonable or unreasonable. The first thing is the reason for the contact, and obviously the more critical it is for your organization to contact an employee out of hours, the more reasonable that contact is going to be. Something that could realistically wait until the next day when they're back at work is going to be less reasonable for them to be contacted about. The second thing is how the contact is made and the level of disruption to the employee. Maybe someone finishes at 5 o'clock. There's something you needed to ask them, but you just missed them walking out the door. Giving them a quick call a few minutes after they have left work is probably going to be less disruptive than calling them in the middle of the night on Christmas Day. It's those sorts of factors that are going to be relevant on the reasonableness test there. And the third thing, the extent to which the employee is compensated for being on call or for working additional hours. If they're getting additional remuneration for being contacted out of hours, that is a key factor which goes towards the reasonableness of the contact. And then on a similar note, the nature of the employee's role and their level of responsibility. The more senior they are in the organization, the more likely there's going to be this expectation of some out of hours contact, or they might have a role where it's just you couldn't do the role without some out of hours contact if they're responsible for emergency changes of rosters, etc. And then lastly, the employee's personal circumstances, including things like caring responsibility. If you know that a particular time of the day when an employee has finished work, they're going to be caring for a dependent, it's going to be less reasonable to expect them to respond to contact during that period than when they're not. So that's what the Fair Work Act says. And then also, all modern awards are being amended to include some additional provisions about the right to disconnect. So the awards will be updated by the 26th, well, on the 26th of August. There are some draft proposals of what the changes are going to be. They're pretty, I doubt they're going to change very much. So we pretty much know what's going to be in there. And all awards are going to look pretty similar in terms of what the changes are. But in a nutshell, they will set out some particular circumstances where contact is reasonable, or refusal of contact would be unreasonable. So looking at the SCHADS Award as an example, the award is going to say that the right to disconnect will not be breached where the employer is contacting an employee or requiring an employee to monitor for contact when they're in receipt of the on-call allowance. So the award has provision for an on-call allowance to be paid when someone is supposed to be ready to be recalled to the employer's premises or a participant's premises, or to perform remote work. It is not going to be breached where the employee is being paid that allowance and the employer insists that the employee monitors for the employer's contact, or where the employer contacts them, or a participant, etc. It'll also not be breached where an employee is attempted to be contacted regarding a roster that needs to be changed on less than 48 hours notice due to an emergency. So as you may know, the SCHADS Award allows an emergency change of roster on less than 48 hours notice. So right to disconnect is not going to be breached when the employer is relying on those provisions, and also won't be breached where an employee is attempted to be contacting regarding recall to work, being called back to perform some work after work is finished in accordance with those provisions. So other awards such as the Aged Care Award are going to have similar provisions, but it's important to get across exactly what they say and the additional abilities they will give you to contact employees out of hours, or to require them to monitor for contact. Some top tips for compliance. I should say that there will be an ability for employees or employers to make an application to the Fair Work Commission if they think that the right to disconnect provisions are being breached. So if an employee thinks that the employer is making unreasonable demands, or if the employer thinks that an employee is refusing contact where that is unreasonable, there is an ability to apply to the Fair Work Commission to make the Fair Work Commission will then make an order saying that the employee has to accept this contact, or the employer has to stop attempting to make contact, etc. So what do you need to do to try and stay away from the Fair Work Commission and try and make things run smoothly? I think the first point is to manage expectations. Make sure that employees know from the start of their employment what level of out-of-hours contact will be required. We would recommend that you do that both by a clause in their employment contract and more detail in a right to disconnect policy. If an employee has signed a contract when they first come on board whereby they're agreeing to a level of out-of-hours contact, it's going to be difficult for them to say down the track, well, I think that's unreasonable now that you're contacting me out of hours in certain circumstances. But you need to, spell out in as much detail as possible what that out of hours requirement looks like in your organization. Is it that employees don't need to monitor their emails after they've left work for the day, but if there's an emergency, you're going to call them on their phone and say, look, this is something you need to deal with. Spell out, where you can, how it's going to work in your organization. Obviously, our contracts at Employment Hero will include a clause about right to disconnect, and we have a template policy in the works too. Understand what the awards say about right to disconnect, because they are going to give you an ability to rely on the provisions of the award and make sure that you're not falling foul of your new duties. And where you can, link the remuneration that someone is paid to the requirement for some out of hours contact. So particularly where you've got employees that you're paying above the award payments to, maybe your kind of most senior folk, make sure that it's explained to them, ideally in the contract, you're paid this salary in recognition of the fact that there's going to be some out of hours contact in your role. If you do all of those things, you've got the best possible argument, I think, that the out of hours contact that you need to make is going to fall on the right side of that reasonableness line. Okay, so let's keep going. The second big thing is changes to casual employment. There is a new definition of casual employment in the Fair Work Act, or there will be from the 26th of August. So this is really key to the test of whether someone is a genuine casual or a permanent employee. And obviously, if you engage someone as a casual when they should have been a permanent employee, there can be some adverse consequences, having to back pay, paid leave entitlements, that kind of stuff. So what is changing? Well, the basic definition is going to be pretty similar to what's in there at the moment. The key aspect to a true casual employee is there is an absence of a firm advance commitment to continuing and indefinite work. So that's very similar to what the Act says at the moment. And the Act will list 4 factors which are relevant to making that determination, which again are very similar to what the law is now. Whether there's an ability for an employer to elect to offer or not offer shifts, and the ability for an employee to accept or decline shifts, that's a factor towards true casualness. Whether there is a likelihood of ongoing work, the less likely that there will be ongoing work, the more likely that's going to be a true casual arrangement. Whether there are permanent full-time and part-time employees doing the same work in the workplace as for casual employees. If there is, that's less likely that someone's going to be a true casual. And of course, whether the employee is doing a regular pattern of work, the more regular their work is, the less likely they're going to be a true casual. So all of those things hopefully are kind of familiar concepts. The big change is that in performing this assessment of whether someone is a true casual, the law is going to say that you need to look at the real substance, practical reality, and true nature of the employment relationship. So look at the relationship as a whole, rather than just at the terms of their contract. So at the moment, under the Fair Work Act, the relevant test of casualness is determined by looking at the terms of their employment contract. Going forward, we're going back to a situation that we had prior to 2021, where you're looking at the relationship as a whole. So it doesn't matter if your contract says you won't work regular hours, you can accept or decline shifts as you like. If the reality is that when you engage a casual employee, you make it clear to them that, well, you are going to have to accept the shifts they offer, and there is an expectation of regular work. The contract is not going to save you. It is looking at the relationship as a whole. So I hope that makes sense. The other probably biggest change with casual employment is a fairly significant change to casual conversion. So the law as it stands at the moment is on the first anniversary of a casual employee's employment, if they have been working a regular pattern of hours for the last 6 months, then employers with 15 or more employees have to offer conversion to permanent employment at that point. unless there are reasonable business grounds not to do so. And if that is the case, they need to inform the employee in writing of that. So there's this proactive obligation on businesses with 15 or more employees. At the 12-month mark, you have to do something. You've either got to offer conversion or you've got to explain in writing why you can't do that. Employees of small businesses currently, it's a bit less onerous. They don't have to proactively make an offer, but if an employee requests conversion after 12 months employment, an employer can only refuse that request on reasonable business grounds. So that is how the law works currently. What is changing is the obligation to do anything proactively, to go out and offer conversion, is being removed, and it is shifting back so that the onus on the employee to request conversion. So for employees in a business with 15 or more employees, they can elect to convert after 6 months employment if they consider they no longer meet the definition of casual employment. For small businesses, less than 15 employees, a casual employee will have that ability to request to conversion after 12 months if they no longer think they meet the definition of a casual employee. So looking at that practically, how's that going to play out? Let's go back to our definition of casual employee. Say you employ a casual new member of staff, and it's clear that they're a genuine casual. They work irregular hours. Sometimes they accept shifts, sometimes they don't. You're ticking all the boxes. It's a clear, genuine casual arrangement. But what about you've moved down the next year, things change. The employee really becomes a kind of key member of the team. They start working regular hours. You work into get into a pattern where you know that they're going to be there every Monday to Friday. You no longer have to offer them shifts to accept. It's just become an accepted way of working that they're going to turn up. You know they're going to be there. They're doing regular hours. All of a sudden, they're not ticking these boxes of true casualness anymore. What happens? Well, if they've been there for at least 6 months or 12 months, if it's a small business, they have a right to say, I no longer meet the definition of casual employment. I want to convert to permanent employment. And if they do that, you can only refuse that request on fair and reasonable operational grounds. But if they don't make that request at any point after 6 or 12 months, they remain a casual employee indefinitely. So this is a positive change, I think, for employers in a lot of senses. So long as you've engaged someone properly as a casual at the start, they're not going to magically transform into a permanent employee kind of against your will. The onus is on the employee to put up their hands and say, I no longer meet the casual employee definition. I want to convert. And then if they do that, you can only refuse that on fair and reasonable operational grounds, such as you know that you can't commit to giving them regular hours anymore because there's going to be some change in the organization or the funding or that kind of stuff. And as is the case now, if there's a dispute about conversion, there's an ability to apply to the Fair Work Commission. So that is that for casual conversion. Moving on, another big change is the casual employment information statement. So as you are probably aware, that needs to be given to new casual employees when they start employment. Going forward, the obligations on providing that statement are going to be a lot more onerous. For employers with 15 or more employees, over on the left, we can say you can see you give them the statement when they start, then you have to give them the statement again after 6 months employment, and then again after the first 12 months of employment, and then again every 12 months thereafter until the end of time. So when they start, 6 months, 12 months, and then 24, 30, what's that, 36, and ongoing and until the employment ends every 12 months. For less than 15 employees, it's less work. You need to give them the statement when they start employment and then on their first 12-month anniversary, but then not again after that. Okay. The third big thing I wanted to talk about is changes for engaging independent contractors. Like with engaging casuals, it's really important to get this right, because if you engage someone as a contractor when they should have been a permanent, when they should have been an employee, there can be significant fines the organisation might face, and they could be ordered to back pay employment entitlements such as the minimum wage, paid leave, etc. So really important to get that right. There is a new definition of employee which is being inserted into the Fair Work Act, and that will be relevant to the employee versus contractor test. So this is changing the law as it currently is. We had some court cases in 2022 which confirmed that when you're looking at the employee versus contractor test, that is determined by looking at the terms of the written agreement between the parties. So the kind of factors which are looked at is how much control does the organisation have over the worker. The less control they have, the more likely they're going to be found to be a true contractor. Can the worker delegate work to others? If they can, that's a key factor which points towards them being a true contractor. Are they paid to achieve a result, or are they paid an hourly wage or salary? If they're paid by result, that is another factor which counts as them being a genuine contractor. So those factors are still relevant, but what is changing, similar to what we looked at with casual employment, is the test to be applied is no longer just looking at the contract. It is looking at the real substance, practical reality, and true nature of the relationship. So again, the contract isn't going to save you. If your contract with your contractors says that they can delegate to work to others, for example, but the reality is that you and they know between you that it's only them that can perform the work. They're not allowed to delegate to others. It doesn't matter what's in the contract. If you're looking at the real substance and practical reality of the relationship, that is what's going to determine whether they are a true contractor or not. So that is the big change. There are also some other things. There will be an easier ability for contractors to challenge unfair contract terms through the Fair Work Commission. And there are also going to be rights for certain contractors called regulated workers in the road transport industry, and those engaged through digital platforms. So, you know, Uber Eats, delivery drivers, those sorts of things. Probably not relevant to people on the call, but just to be aware that those are the changes too. So how are we doing for time? A few more minutes left, I think, for me. So those are the big three things, I think, which are changing on the 26th of August. I just thought it was worth looking at a couple of other things. So as you're probably aware, there are some forthcoming changes to the SCHADS Aged Care and Nurses Award. So back in March, the Fair Work Commission made a decision to increase the wages and amend the classification structure for direct and indirect care workers working in aged care. That included changing the aged care classification in the SCHADS Award, which covers people working in aged care where they're providing assistance to elderly people in their own homes. The classification structure in the SCHADS Award was going to be changed to match the classification structure in the aged care award, which of course is sort of residential aged care. And also assistants in nursing were going to be taken out of the nurses award when working in residential settings and placed into the aged care award. So that was one big change. Also, a decision was made to increase the minimum wages at various rates up to 28.5%. That was inclusive of the 15% increase that had already been implemented the previous year, I think. And so when the Fair Work Commission made that decision in March, they said that we're going to have a think about the date that these new provisions should come into force. They have now made a decision about that, and they have decided that the pay rises are going to come into force in two tranches, so the 1st of January 2025 and the 1st of October 2025. That is going to match the dates that the government has committed to providing funding for the wage rises. So there's a link to the decision there, and you can see exactly how that's going to work. The one thing which they hadn't decided in this recent case was whether there is a need for assistants in nursing who are working in home care for aged persons, whether they need to come within the home care stream of the SCHADS Award. So that decision is still pending. Once we have that, which we expect imminently, you'll be able to see exactly what the new classification structure in the awards look like. So just be aware of that. And then finally, just wanted to highlight as well that portable long service leave for community service employees is being introduced in New South Wales. It's already in place in Victoria, Queensland and ACT. So portable long service leave, as you may know, is the concept that someone working in a particular industry, community services in this case, can change employers but keep their long service leave entitlements with them when they move from employer to employer within that same industry, whereas the usual rule is that your long service leave entitlements are just linked to one employer, and if you leave that employer, you lose them. So in New South Wales, this ability to carry long service leave around with you as an employee is being introduced for community service employees in New South Wales. The entitlement is going to be 6 weeks of long service leave after 7 years of employment rather than 2 months after 10 years. And how this will work, like the other schemes, is employers will be required to pay a levy, pay a fee in respect of eligible workers to basically a government body, and then that government body will pay out the long service leave when the employees are eligible. That law has passed, but we don't know when it's going to come into effect. But the government has indicated that it's likely to be 1st of July 2025, so a bit of time to prepare for that. So that's all I was going to talk about for the moment. So I hope that was useful, a bit of a kind of whistle-stop tour through some of the changes, but hopefully at the very least it gives you kind of some signposts about things to be looking out for. I am going to hand back or am I handing over to Annie, I think, and she will give you a bit of an explanation about what we do in the advisory team at Employment Hero and how we can help with all of the sort of stuff I've mentioned. So Annie, over to you.
Thanks for that. So obviously quite a few changes coming up through the next few months, and definitely a lot that you have to be aware of. So like Simon mentioned, I thought I'd jump on and briefly touch on our HR advisory subscription, which we have here at Employment Hero, and how can this really help navigate this difficult space, and hopefully ease the burden of having to understand and prepare for all these changes. So our advisory subscription is our on-demand advisory service, which aims to connect employers and managers with our team of HR experts via phone or email. Our team can provide a really broad range of advice on HR matters. So everything from navigating those tricky modern award questions to guidance on how to manage sensitive employee issues like those disciplinary or termination processes, and of course, advice on all these changes that we have coming up as well. We've worked really closely with many NDIS businesses for a number of years now, so we're particularly well versed in understanding the industry and all the intricacies that come with the SCHADS Award and the Aged Care Award. We're quite aware how difficult these awards can be in your business, and our team has a pretty in-depth knowledge of advising on those tricky issues like sleepovers, broken shifts, classifications, the various award streams as well. The advisory line is a really fantastic first step in providing an avenue for all your questions about these upcoming changes, how these apply to you, and all the information you might need to remain compliant. But the advisory line is only one aspect of that service. We also have a compliance health check in that service, which helps to identify the relevant modern awards, assess your level of compliance. And for SCHADS businesses in particular, we're looking at what sector of the award applies to and what roles might fall within those different sectors. So that's quite important with the upcoming changes as well. We also have our document library with heaps of resources and templates to support all your HR needs. And as part of this, we have a number of guides focused specifically on SCHADS. And of course, we have resources for these upcoming changes, like we have new contracts and policies as well to keep on top of these and to help prepare for these in your business. Finally, we're obviously very confident in the advice that we give. So our subscription does include legal representation in the event of a workplace claim as well. The aim of the advisory service is really to give businesses the tools to manage your employees compliantly and make sure you're aware of all your obligations as an employer, even with all these rapid changes that are happening. Our team is incredibly passionate about this space and making it easier for you to navigate your responsibilities, which can be incredibly difficult when you're running your business, which we are very aware of. So if you have any questions about the advisory service, please don't hesitate to reach out to myself or Simon. I think our details are at the end as well, but I look forward to hopefully connecting with some of you after the webinar and answering some of your questions about these changes and how we can help navigate them. I know there's quite a fair bit coming up. I think over to Courtney now to walk us through some of the other features of Employment Hero.
Beautiful. Thank you, Annie. That was really valuable. Simon, next slide for me, please. There we go. In addition to our HR advisory services, we also offer a HRIS platform. Now, systems and advice do tend to go hand in hand, and our HRIS system can certainly help you guys navigate some of those upcoming changes. So some examples of this, and I certainly won't do a feature dump on the full HRIS, but for example, employees exercising the right to disconnect can limit when they receive notifications on both the web browser as well as their mobile phone app using the customizable notification frequency settings. Not only that, but as both Simon and Annie touched on earlier, we do have that document repository, including policies as well as contracts. But the beauty of the HR system itself is you can have those policies automatically reassigned out at regular intervals, say every 12 months, just as a refresher to ensure everyone is on the same page. Now, that can occur automatically in the background because we appreciate a lot of you in your businesses will wear many hats and you don't really have time to chase down who's marked off this policy, who's read that one, etc. Not only that, but because we are a cloud-based platform, we are able to track what employees have viewed as well as acknowledge those policies and procedures. Just in the unlikely event that anything does ever go wrong, you are protected and have that digital tracking functionality too. In terms of casual employees and some of those requirements around the information statement needing to be assigned out to everyone, that occurs automatically via our platform whenever you onboard a new casual employee or change an employee type to casual. The additional Fair Work information statement also goes out with that one. Now, we update that statement whenever that statement does get updated on your behalf. So it's one less thing that you guys have to think about and really speaks to the benefit of automations, particularly in HR. We also have things like customizable onboarding workflows where you can set automated reminders for 6, 9, 12 months time to review how someone is going, what their work patterns look like. Do you need to be evaluating whether you're moving them into a part-time or full-time role? So you can set that as part of the onboarding so you don't have to use a paper-based diary or forget about an Outlook calendar invite 12 months down the track. In terms of changes to independent contractors, with our HR system, you can manage all of your employees as well as your independent contractors side by side in a centralized system, removing the need for things like double handling and that manual kind of chasing up sort of situation. There are a range more features and benefits of the HR system, but these are just a few in terms of how they relate to the upcoming legislation changes and the impact that they can have. Simon, I'm just going to get the next slide, please. Now, that is why Employment Hero, in partnership with ShiftCare, are bringing to you today a webinar-specific offer. So all registrants for the webinar are eligible for the offer I have up on the screen. So that is $1 off per employee for our HR Platinum plan or $2 off per employee for our HR advisory service. Now, these services and platforms are available in a modular delivery, so you can do one or the other, or you can certainly bundle them together for both. If you would like to redeem the offer, now you must enter your details on the form I'm going to post in chat here, and we'll also provide this via email to you guys after the call. If you are interested or you would just like a little bit of extra information on anything we've presented today, please pop your details into that form and one of our team will reach out to you in the next few days. Now, that offer there up on the screen is valid until the end of August, so you have a whole month to utilize that one, subject to our minimums and that sort of thing. If you have any questions regarding the offer or whether you might be eligible, you're more than welcome to pop it in the Q&A chat or into the form itself. Now, I know the chat is going off at the moment, so I'm going to get Simon to hit the next slide and we're going to launch straight into our Q&A session. So I have a few in here I might read out to you, Simon, if you're pretty happy to answer them. I think most of them are for you.
Yeah. All right. I mean, I'm in the Q&A as well, so I can just read them out and answer them like that if that's easier for you.
That works well for me. Over
Okay.
to you.
All right. So we'll see how many of these we can get through. This question has come up. I can see a few people have asked the same sort of thing. So for the definition of a small business employer, I said in the presentation, small business is less than 15 employees, non-small business is 15 or more, and that there were several rules which applied differently for small businesses and non-small businesses, as there is in many things in the Fair Work Act. So how do you calculate the number of employees? Is it full-time equivalent or is it a head count? And it's definitely a head count. So it is the number of employees you employ, regardless of number of hours, if that makes sense. Full-time and part-time are treated the same. You also include casuals, but only casual employees that are doing regular hours, but all of those people are included, full-time, part-time, casuals doing regular hours. You do a head count of all of those. If you're less than 15, you're a small business for the purposes of the Fair Work Act. So I hope that answers that one. Second question, I presume this was about the right to disconnect. Is this already in place for other industries and new to the SCHADS workplace, or just new in general? It is new for everyone. It is an obligation that applies to employers regardless of industry. But each award will have its own right to disconnect provision, which spells out certain situations where an employer won't be breaching the right to disconnect obligations. For example, in the SCHADS Award, it says when an employee is being paid an on-call allowance to be on call, you're not going to breach the right to disconnect provision by requiring them to be monitoring their phone for calls, or by when you call them. So it's important to look at the award that applies to you, but the general right to disconnect provisions applies to everyone. Okay, next one. Please supply an example of an email signature which incorporates a right to disconnect. Now, I presume that is asking what an email being sent out by an employer would look like to avoid breaching the right to disconnect. So I presume this is asking, you see this relatively commonly these days, where someone will send out an email and it'll say something like, I work odd hours. I might be sending this out in the middle of the night. Just because I'm doing that doesn't mean I'm requiring you to respond to that. My working hours may be different from yours. If that's what that is about, which is a really useful thing to have in your email signature to make it clear to employees whether they're supposed to be responding to an email that they receive out of hours or not. We can certainly help with some wording with that if you want to get in contact after the webinar. Next question, is there a minimum number of hours for part-time when converting someone from casual hours? We have some staff who only work 3 hours per week by choice, with one participant. That's a great question. The legislation doesn't say that there is a minimum number of hours that someone has to work to be eligible for casual conversion. What is more important is whether they're working those hours regularly. So you might have a casual employee who only does 3 hours a week, but if they do those 3 hours in a set pattern, they always work on a Monday from 12 noon till 3 p.m. and it's an expectation that they work those hours every week in that pattern. That is likely, I would say, to mean that they're going to be eligible for conversion. So it's a regularity of hours as opposed to the number. That said, the more hours they do, the more likely it is that they're going to be eligible to convert, I would say. If you've got a casual employee who's doing a 38-hour week and working, 9 to 5, Monday to Friday, that I think is harder to say that they are a true casual than if they were doing a smaller number of hours. So it is a relevant factor, but there's no absolute rule which says you only get conversion when you've been doing more than X number of hours. So I hope that is helpful with that one. Okay, what's next? Part-time employee has agreed hours in their contract. What is the employer obligation if they lost their regular hours? That's a great question. A lot of awards have an obligation to provide part-time employees with a set number of hours, or for those hours to be worked in a set pattern. So if there's a requirement along those lines, and you've committed to giving your employees, say, 10 hours a week, what happens if in a particular week you can only provide them with 8 hours? Do they get paid for the additional hours that you couldn't provide them with work? I think is kind of what that question is getting at. That's not a particularly straightforward one to answer in a kind of really short and pithy way, because the SCHADS Award, for example, has provisions which allow you to change an employee's hours where there's been a client cancellation. So where the client has or a participant has cancelled, and therefore hours need to be reduced. There is an ability in some circumstances to allow for that, but the provisions are quite complex, and they all depend on how much notice the employer has of the client cancellation, how much notice can be given to the employee. So there's not really a one-size-fits-all answer to that. That there is definitely abilities to avoid having to pay someone for hours that they haven't worked, but it all depends on how much notice they're given, what is the reason for the change as well. Equally, the SCHADS Award has stuff about changing someone's roster in emergency circumstances. So it's really going to depend on why those hours are not available to them. Really happy to speak about that offline if you can give us some more information about exactly the situation you're looking at. Okay, next one. If the casual staff do not want to transition to permanent part-time, yet have consistent shifts for the past 6 months, can you take shifts off to give to those other staff accepting permanent part-time employment? So if we're looking at the new obligations under the Fair Work Act from 26th of August, there is no kind of proactive obligation on an employer to offer conversion anymore. Conversion only bites when an employee puts up their hand and says they want to convert. So if they don't exercise that right to elect to convert, then you don't have to offer them conversion, and they will stay as a casual indefinitely. If that is the circumstance, then the nature of their casual employment means that you don't have any obligation to offer them set shifts or indeed any shift. So I can't see why there would be any issue in you saying to a casual employee who wants to remain as a casual employee, I need to allocate these shifts to the employees who I've got an obligation to provide with a set pattern of work. it's kind of part and parcel of being a casual employee that you don't have a right to particular shifts or indeed to work at all. So I don't see that there would be an issue in that of itself. But again, you know, if there's other things going on in the background that might be relevant, I'm not sure. But again, happy to sort of talk in more detail about that one if you need further guidance. How are we doing? 12:57. Maybe I'll take one more. Where have we got up to? Done that one. If a worker declines to offer of permanent part-time as an employer, are we as an employer covered if they try to get the back pay of leave? Oh, this is a good question. So I think this is asking, so someone is a casual employee, you've offered them a change to part-time employment, they've refused it, and then down the track they make a claim, I suppose, that they were a true permanent employee all along. Can you say that we don't have to back pay you your leave because you refused the offer of conversion? Well, under the new provisions, you of course you don't need to make an offer of conversion at all, but unless someone elects to change from casual to permanent employment, they remain a casual employee indefinitely, even if they no longer meet the definition of casual employment. So long as they were properly engaged as a casual as the start, then you're not going to have an obligation to back pay them leave. It can't work like that anymore. The only way they convert is if they elect to do so. So as long as you've properly engaged them as a casual on day one of their employment, there can't be a finding that they were a permanent employee down the track. So that's one of the positive things that is changing about the legislation. I hope that answered what you were asking, but if it was something else, do reach out and let me know. Okay, 12:59. I know I have only got through a smidgen of what was asked, but we will have a record of all the Q&A questions. So I'm sure we can put together a sort of FAQ document and share some answers to the things that we didn't get to. But thank you for all those questions. That's really great to see what people are thinking about and really useful for us too. So Courtney, I'll hand back to you.
Thanks, Simon. I'll keep it short and sweet, guys. Just on my final slide here, just my contact details. If anyone does have any additional questions from today's webinar or would like to know some more information about our HR advisory or HR services and how to navigate those changes for your small business. So feel free to reach out to me direct via that email. The link to the registration form is also in chat, and we'll send a follow-up email containing that after the webinar. Just a final reminder, everyone will get a copy of the slides as well as the recording. Lucky last, back to Heather at Shift Care to wrap things up.
Thank you, guys. Thank you very much for this amazing, insightful session. As always, we've had a ton of questions. So like the team said, we'll make sure we get those all answered for you. Big thanks to Courtney and Simon and Annie and Jake from our partners at Employment Hero for providing this free session for our providers. It's been very helpful. We can see there's lots of questions. It's a very important thing to make sure that we have understanding of for the providers. So thanks again, everyone. Keep an eye on your inbox. The replay will be coming to you soon. And as always, thanks for being here. Thanks, everyone.